You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Welcome back from a lengthy vacation, Bill.
Thank you.
Good to see you.
Thank you.
So let's start off with the case of the week. It's, of course, the city of Detroit. And from what I've read, Detroit as a city is as broke as any city can get. But some creditors, nonetheless, are going to challenge the city's right to go through the bankruptcy process. We're going to see a lengthy trial on eligibility coming up. Bill, have the turn of events given you an opportunity to consider whether Congress should modify the bankruptcy code as it pertains to Chapter 9 municipal bankruptcy law?
You bet it has. Every one of the recent spate of Chapter 9 municipal bankruptcies has entailed an enormous fight at the outset, sometimes going on for more than a year, about whether the municipality is eligible for bankruptcy. Now, everybody knows these municipalities are bankrupt. The question is, are they eligible?
Right. And this is a process that's messy and it varies from state to state.
Exactly right. A very fact-intensive, difficult examination that must be undertaken at the outset of the case. And unfortunately, while all this is going on, not much else is happening in terms of reorganizing the city's expenses. I suspect that, in some of these cases, the fight over eligibility could represent half of the cost of the entire Chapter 11 case, meanwhile slowing it down very considerably.
Half of the cost is going to be on this trial.
It could be. It's hard to say.
Crazy.
In Detroit, the judge is very smart because he's making this thing get finished real quick. That didn't happen in other municipal bankruptcies. You simply cannot avoid altogether the question of eligibility. Congress did learn in the prior Bankruptcy Act that went out of business in 1978 that fights over eligibility or good faith at the outset really don't produce anything. And so therefore, for that reason, for ordinary companies, there is no similar fight over eligibility. But for constitutional reasons, I think you have to have it with a municipal bankruptcy. But that doesn't mean it has to go on forever and it has to cost so much. Traditionally, in the American system, both parties pay their own legal expenses, regardless of who wins and who loses. I'm thinking it's time for Congress to consider changing that rule so that in the context of a municipal bankruptcy, if a creditor, group of creditors, labor unions, or whoever challenges unsuccessfully the right to be in bankruptcy, then in that event, that creditor pays the city's legal expenses.
That would be a big change to the code.
I will bet you dollars to donuts that would end these fights immediately. And I frankly don't see any constitutional problem with it either. So I think it's something Congress ought to think about.
And Bill, we have a new filing to report while you're on vacation. The Houston Regional Sports Network was the target of an involuntary Chapter 11 petition by Comcast, one of the three joint ventures that own the network. Now, we haven't had a sports bankruptcy really since the Los Angeles Dodgers case. Is the Houston case shaping up to be as interesting as the Dodgers case?
Well, I'm certainly hoping so, because we need a really fun sports case, and nothing better to write about or read about than those. This network is a joint venture between the owners of the Houston Rockets, the basketball team, the Astros, the baseball team, and Comcast, a broadcaster. They together formed this joint venture to, in large part, show the games of the basketball and baseball teams. According to the Rockets, this bankruptcy resulted because Comcast and the Astros were at loggerheads and deadlocked on how to conduct the business, how to refinance it, how to put more capital in, whether to sell it or what have you. As a result, Comcast got together with some other creditors and filed an involuntary bankruptcy petition. The Astros turned around immediately and filed papers saying it ought to be dismissed, thrown out of court, let the people fight it out in state or federal court. The Rockets, on the other hand, have filed their own papers saying, no, we think this thing ought to be in Chapter 11. There ought to be a responsible officer running the company, they say, because of the deadlock, but nonetheless it should be in bankruptcy. This case is before bankruptcy judge Marvin Isgur in Houston, who is quite a man. He has the stature, I guess, of what you would call a defensive end in football. And that, in some ways, is the way he conducts his cases, because he pushes people around just like a defensive end. What Mr. Judge Isgur likes to do is to get impossible cases fixed. Mm-hmm. And I believe that that is exactly what he's going to do. In this case, he is going to crack heads all the way around and get something done that is beneficial for the citizens of Houston who like to watch sports on TV.
All right, and it's advance sheets time, because while you were out, several of our more devoted listeners complained about being deprived their weekly dose of advance sheets, where we report on new opinions coming out of bankruptcy courts all around the country. What are the most important decisions that they missed in the last month or so?
So far, the most important comes out of the Third Circuit in Philadelphia, case called Simon versus Firecard Services. This decision from the Third Circuit accentuates an existing split of circuits. The question is, does the Bankruptcy Code preempt the Federal Fair Debt Collection Practices Act? In other words, in simple or more simple English, if somebody is in bankruptcy and claims that a lender used improper collection methods, can that bankrupt sue under the FDCPA? Two courts, namely the Second Circuit in New York and the Ninth Circuit in San Francisco, said, nope, bankruptcy preempts it. You can't bring a FDCPA lawsuit if you are in bankruptcy. The Seventh Circuit in Chicago held the other way and said, no, there's no problem with it. The Third Circuit came down a little bit in the middle by saying that you can have the two statutes coexisting and bring lawsuits so long as both can be enforced without conflict. This is a case that I think eventually will go to the U.S. Supreme Court, and I certainly hope that as it goes up and is considered in other circuits, people keep in mind that, frankly, those who are in the most need of protection by the FDCPA are none other than bankrupts, because these are people who couldn't pay even if they had the money, which of course they don't. And for that reason, I think courts ought to give some serious consideration to not being so stingy in allowing bankrupts to bring these kinds of lawsuits.
And Bill, what was the second most important decision?
Well, that came out of the Fifth Circuit in New Orleans, a case called Frazen versus Haynes and Boone. This new case is an offshoot of a case from about 2 years ago called Reed versus City of Arlington. In the Reed case, the court en banc, that is to say, all of the circuit judges on the Fifth Circuit, got together and decided that if a bankrupt commits a sin by failing to disclose the existence of a lawsuit, under the doctrine of judicial estoppel, the defendant cannot insist on having the lawsuit dismissed because it was not disclosed. Basically, the Fifth Circuit said back in the case 2 years ago that the sin of the bankrupt should not be foisted onto the trustee and on the creditors, and so therefore, in that particular case, allowed the trustee to continue the lawsuit, although it had been non-disclosed or withheld by the bankrupt. In the new case, the Frazen case, the facts were slightly different. In that one, there was only about $44,000 of claims that were held by creditors. So therefore, this personal injury defendant said, listen here, that's okay. Let the trustee sue, but the maximum damages the trustee can recover are $44,000. Well, Circuit Judge Edward Prado on the Fifth Circuit did not buy that argument. He said, no, Reed versus Arlington has no such limitation, and we're going to allow the trustee as the plaintiff to sue for the full amount of damages. In a way, it doesn't much matter because, that is for the defendant, because whatever is collected, Prado says, after the creditors are paid in full and the fees are paid in full, any excess goes back to the personal injury defendant. Now, you might want to say, well, why all the bother? Well, here is the reason. More often than not, these kind of cases are being pursued by a lawyer on a contingency basis. So therefore, in this case, if you could only recover a maximum of $44,000, well, then I don't think any law firm would ever have taken the case. But if there was a 6 or 7 figure recovery, law firms would line up down the street to take the case. Ergo, there is a good reason for having no limitation, as Judge Prado said. I had an opportunity to confer with an esteemed bankruptcy law professor who said, interestingly, that he has some concern about whether or not this is good law that would be similarly adopted in other circuits. However, and more important, a very smart judge whom I know saw a different angle to these two cases entirely. In the Madoff cases, we have been talking about how the notion of in peri delicto has limited the Madoff trustee from being able to sue a bunch of people and recovering more money for the defrauded investors in Madoff. In peri delicto basically means that any sins or fraud of the bankrupt, in this case Bernie Madoff, is foisted off onto the trustee, and because the trustee is assumed therefore to have committed fraud himself, he cannot sue in many instances. This very smart and very tall judge whom I know said that maybe these two cases can be used to undermine the applicability of the in peri delicto defense. Because in these cases, the issue was one of what's called, the legal term is judicial estoppel. So if judicial estoppel is not imposed in these cases, then perhaps also this is the first chink, the first major circuit court case to undercut the in peri delicto defense. Let's keep our eyes out for this. If my buddy friend on the bench is right about it, this is an even bigger case than we might think.
Good stuff, Bill. Thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out his column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Pacchia. Thanks for watching.